one hearing today, but first, I'll ask for bill introductions and Representative Smith.
Thank you, Mr. Chair. I do have a bill regarding PTSD and work comp situations, and it is an RS number of 0092.
Very well. Representative Parker, do you have a comment?
No, Mr. Chairman, I have my own bill introduction.
Oh, I'm sorry. I'll come right back to you. Any objections to the bill introductions by Representative Smith? Seeing none, it's accepted. Representative Parker, bill introduction.
Thank you, Mr. Chairman. I have RS 0869. This is an act concerning cannabis. It would legalize and regulate cannabis for recreational use.
Thank you. Committee, without objection, it's accepted. Representative Parker. Other bill introductions. Seeing no other bill introductions, bill introductions are closed. We'll open the hearing on House Bill 2199, authorizing sports wagering under the Kansas Expanded Lottery Act. Matt?
Thank you, Mr. Chairman, and good morning, committee. So I have a lengthy memo I provide you on House Bill 2199. I'm going to try to run through it quickly for the committee. The bill would authorize sports wagering in Kansas. It contains 14 new sections of law that would be part of the Kansas Expanded Lottery Act. Because under the Kansas Constitution, it requires that all forms of lotteries must be owned and operated by the state. Many of the provisions of the Kansas Lottery Act and the Expanded Lottery Act would be applicable to sports wagering under the bill. Kind of running through some of the major provisions of the bill, Section 1 would authorize the lottery to conduct sports wagering, either through by the lottery itself, through sports wagering retailers who contract with the lottery to conduct sports wagering on behalf of the state, or through casino or racetrack facility managers pursuant to their KELA management contracts. The bill would allow the lottery to approve interactive sports wagering platforms for use by the lottery and the facility managers to offer sports wagering through the internet and mobile device applications. So under the bill, any entity that conducting sports wagering would be referred to as a sports wagering manager, and the bill defines sports wagering as placing bets on one or more sporting events or any portion of a sporting event. Sporting events exclude horse and greyhound races subject to the Kansas Parimutuel Racing Act, and any event where a majority of the participants were under the age of 18. The bill would establish two categories of sports wagers for purposes of what data source a manager could use to verify the outcome of the event. So you have Tier 1 wagers, which are bets on the final score or outcome of a sports event, and managers would be allowed to use data from any source for determining those wagers. For Tier 2 wagers, all other types of bets are two-tier wagers are any other kind of bet, and a manager could only use official league data that was provided by the relevant sports governing body, provided that data was readily and accessibly available on commercially reasonable terms. Section 2 of the bill pertains to contracts between the lottery and sports wagering retailers. Retailers would be selected by the lottery in a similar fashion to how lottery ticket retailers are selected under current law, and the lottery would not be allowed to contract with more than 1,200 sports wagering retailers in the state. Section 3 would permit the lottery to select an interactive sports wagering platform for online sports wagering. Any casino or racetrack facility manager that contracts to manage sports wagering could use the selected platform and could request the lottery for approval of one additional platform. Moving to Section 4, it would allow the lottery and any casino or racetrack facility manager to enter into a marketing agreement with a professional sports team for the purpose of offering sports wagering at the home stadium of that sports team. Section 5 would establish regulatory restrictions on advertising by sports wagering managers. Some of those restrictions include not targeting minors or vulnerable people, disclosing the identity of a manager, providing problem gambling and addiction support information, and not using false or deceptive advertising. Section 6 of the bill would allow a sports governing body such as the NFL to request that certain sports events be excluded from sports wagering. The lottery would review any requests and receive input from the managers before determining whether to approve or deny that request. Section 7 would require that sports wagering managers use reasonable methods to prevent individuals that have a conflict of interest from placing bets. The wagering managers would also be required to cooperate with investigations and report any potentially illegal activity to the lottery, Racing and Gaming Commission, and the sports governing body in certain instances. Section 8 of the bill would require sports wagering managers to maintain records of the betting activity. The information be required to be made available upon request, and all disclosures would be subject to a data sharing agreement between the lottery and the sports governing body, pursuant to Section 9 of the bill. And Section 10 would provide a cause of action for the state and the sports governing body against any person who knowingly engaged in conduct to improperly influence the outcome of a sports event for financial gain. Section 11 would provide for individuals to place themselves on a self-exclusion list so that sports wagering managers would not allow those individuals to place sports wagering bets. Section 12 would establish the Sports Wagering Receipts Fund. So all revenues from sports wagering would be deposited weekly in this fund. Each month, the lottery would certify the amounts that were to be paid to the retailers and to the facility managers pursuant to their management contracts, and then the remainder would be transferred to the lottery operating fund. The bill would provide that the state's portion of sports wagering revenues from wagers placed would be whatever for the retailers would be whatever is specified in the contracts with the sports wagering retailers. And then in the management contracts with the casinos and the racetrack facility managers, the state's percentage would be 20% for wagers that were placed through a mobile application and 14% for wagers that were placed in person. The sports wagering revenues are all wagering revenue generated from sports wagering in an amount equal to the total wagers, and then you subtract out any voided wagers and any amounts that were paid as prizes to the winners. So Section 14 of the bill would create the new white-collar crime fund to be administered by the Attorney General. The first $750,000 of lottery operating revenue from sports wagering would be transferred to that fund to be used to investigate and prosecute gambling and other financial crimes. Section 15 of the bill would require the governor to exercise good faith in negotiating existing tribal gaming compacts to include sports wagering. The bill does also include provisions that people might be familiar with as known as iLottery. Sections 21 and 24 of the bill remove the current prohibitions on internet-based lottery games. The bill would allow the lottery to sell online lottery ticket games as long as the game did not, 1, functionally operate the game the same as a slot machine, 2, allow for the redemption of prizes of $600 or more, and 3, extend credit for the purchase of a lottery ticket. So under the bill, it would also amend a number of statutes in the Lottery Act and the Expanded Lottery Act to provide for the regulation of sports wagering. It would add new rules and regulation requirements for the lottery to regulate sports wagering, amend criminal history record check certifications to require background checks for individuals involved in sports wagering, would include sports wagering in the gambling prohibition for individuals that were under 21, and then would apply that same prohibition on gambling by individuals with a conflict of interest to sports wagering. There are some criminal provisions that are changed as well. Section 17 would exempt sports wagering from the criminal gambling laws. Section 16 would create the new crime of misuse of non-public sports information, which is placing a sports wager based on materially non-public information. A violation of that section would be a level 5 non-person felony. The bill also raised the penalty for sports bribery if the offense was committed with the intent to obtain financial gain in connection with a sports wager. And that would increase from a level 9 non-person felony to a level 5 non-person felony. Section 32 would amend the current statutory prohibition against gray machines to specify that the state, through the Attorney General and Racing and Gaming, have original jurisdiction to investigate and prosecute violations of that prohibition. And then sections 33, 34, and 35 amend the state debt set-off statutes to include sports wagering retailers as an entity that may act on behalf of the state in withholding prize winnings from individuals who have a debt owed to the state or a municipality. And then lastly, section 36 would increase the transfer from amount to the problem gambling and addictions grant fund from $80,000 a year to $100,000. And I know that was a quick run through. I'd be happy to try to answer questions the committee may have.
Questions for the reviser? Not now, at any time. You can, if you have questions, we will stop and ask the reviser. Seeing none, thank you, Matt. You did a great job as, oh, I'm sorry. Yes.
Thanks, Mr. Chair. My question is on page 12, line 15. Could you go through, does this change the way that we treat fantasy sports leagues? Could you just go through what this bill means for that, please?
I'm sorry, you said page 12, line what?
Line 15, number 9.
Oh, so no, that's, thank you. That's current law. So we're in a definitions section and yeah, that's unchanged. There was a bill a few years ago that explicitly legalized fantasy sports. So that this would not address fantasy sports. That would be unchanged under this.
Okay, I believe I have one more. Representative Wagner.
Thank you, Mr. Chairman. You mentioned about section 21 and 24 allowing what is known as iLottery. Is that directly tied to sports wagering, or is that just a new type of lottery that would now be allowed? Do you understand the question?
I think the lottery may be able to answer better how they intend to use it. So I'm not. That's why I'm holding back a little. It would authorize it, subject to those restrictions that I detailed. But how it may be implemented may be better answered by the lottery.
Okay, thank you.
Representative Parker, you have your hand up.
Sorry, Mr. Chair, I just need to lower that for my bill introduction.
Okay, thank you. Thank you. Well, with I have no other questions of the reviser. I'm going to turn it over to my vice chair.
Thank you, Mr. Chair. We will go ahead and open up the proponents. Up first, we have the distinguished chairman, Representative John Barker, as our first proponent. Chairman Barker, welcome to committee.
Thank you, Madam Vice Chair. I believe in my 6 years here, this is the first time I've actually testified in front of the committee. And a few years ago, I would not have envisioned testifying in front of the committee. First, I'd like to make a comment. Do you gentlemen like my coat today? I wear it because of my good friend, Bud Estes, who used to be the chairman of the Senate Fed and State, and we worked really well together, and we worked on these bills together. And, you know, he was probably the best dressed person in the legislature. At one time, he told me he thought he owned 400 suits and probably twice as many ties. But the history behind this jacket, we had worked on a couple of bills over the years, sports book, and I'll get into that in just a second. But we were in Minneapolis at a conference for gaming states. And we were going out to dinner, and my wife was with me. And Bud Estes could never walk by a men's clothing store without going in. So he drugged me into a men's clothing store, and he ended up buying 2 suits. He was trying on suits. And my wife was there, so I don't buy anything unless she approves. So she picked out a suit for me. And it's a blue suit that I wear on occasion. So we're getting ready to pay for it, and Bud says, he's over here at this rack at sports jackets. And he said, you need one of these, and because we bought a suit, we can get these sports jackets for $50. I said, well, Bud, I really don't wear a lot of sports jackets. So he picked this one out for himself, and he said, you need one too. And I thought, okay, I'll buy one on the condition that at some point in time we will go to conference committee, and the chairman of the Senate Fed and State and the chairman of the House Fed and State will walk in and have the same coats on, same jackets. We thought we'd get a news story out of that. But I'm wearing this today, and this is the first time I've ever worn it, and I've probably owned it a year and a half. It's not really my color, but I'm wearing it today in honor of my good friend, Bud Estes. We would have breakfast a couple of times a couple of mornings a week, and we went out to dinner several times during the legislative session. But, you know, there's one in his closet exactly like this. And unfortunately, we'll never get to go to conference committee and wear the same jacket. With that said, I'll try to get back on the bill. The Supreme Court of the United States made a decision, and I think it was 2018, which allowed states to have sportsbook. Prior to that, only the state of Nevada could have sportsbook. As soon as that started, Bud and I started talking, and we decided we would introduce a bill. I think it was introduced a bill in 2019, and then we tried to bring all the parties together. In fact, one day we had a joint meeting in this very room, and we had all the interested parties in the room. And Jason Long was our reviser, and we would have him read each section, and we would give the parties an opportunity to object or to agree. What was interesting is the casinos objected to every sentence, and it was a little frustrating, and Bud and I finally adjourned the meeting and left. And we used to talk about this, and I'll talk about it to you. All gaming in the state of Kansas is owned and operated by the state of Kansas based upon our Constitution. We contract with casinos. They work for us through our lottery. And we have tried to work compromises with them, and it's been very difficult. What I do have, and I'm going to hand it out to you, there's a Senate Bill 84. Jeannie, if you'd hand that out to everyone, because I want to go through our bill versus the Senate bill. And it is my belief that the Senate bill was written by the casinos because they are in charge of everything. And, you know, it's like the tail wagging the dog. And as soon as that gets handed out, it's the comparison sheet. The members, please. And I think we may have a few for the audience also. But as they're handing them out, I'll just kind of briefly go through them. We have the first section, the issue, the second section, which is the House Bill 2199, which is the bill we're hearing today, and the other one is Senate Bill 84. If you'll notice, the first category, Kansas Lottery, it authorizes the Kansas Lottery itself to operate sports wagering through one or more interactive sports wagering platforms, which means they would contract with the casinos, or in this bill, they could also contract with convenience stores. There's 1,700 convenience stores or Buffalo Wild Wings or sports bar type things. that can sell lottery tickets presently. This bill would authorize them to sell Tier 1 betting. Tier 1 being a straight line bet, who's going to win the contest, and there may be a point spread in between. You would be able to go in, buy a ticket at Casey's General Store or some other convenience store, but it would only be Tier 1. Now, I'm going to make this point. It was asked in the Senate committee, and apparently nobody were able to answer that. Well, what if there's a big loss? By some phenomenon, a team that no one expected to win, and the odds were 100 to 1, and suddenly that team won, they had to pay out. Who would be responsible? No one was able to answer that on the Senate committee. They want to know if it was the convenience store who was liable or the state of Kansas who was liable. It was a good question. The answer is neither of them would be liable. The lottery would contract with like Scientific Gaming or some other agency that does that, and they would be the ones that would have to pay if there was a loss. Overall, over a year period of time, that's very rare if that would happen. The second section is casino gaming facility managers. It just authorizes the casino managers to contract with the Kansas Lottery to manage and operate sports wagering. The Senate version is the same. On the third section, racetrack gaming facilities, which we have no racetracks in the state of Kansas. But it authorizes racetrack managers to contract with the Kansas Lottery. It does not authorize it in the Senate bill. Retailers. The House bill authorized the Kansas Lottery to contract with up to 1,200 retailers to operate Tier 1 betting. Again, the Tier 1 is just a straight line bet, winners and losers. Sports retailers will also offer sports wagering in person at retail locations. The Senate version does not do that. The Senate version is just all about the casinos. Mobile app application. Kansas Lottery may select a mobile application for use by the lottery or any contracting casino, racetrack manager, or offer both Tier 1 and Tier 2. Tier 2 is in-game betting. If the casinos would retain the Tier 2 betting. If you're watching a game and you want to make a bet on who's going to score in the third quarter, you would be able to do that. You would not be able to do that at a convenience store. They only have Tier 1. And the reason we thought it was important to have a Tier 1 is if you're in Colby, Kansas, and you're driving up to Casey's, and you sometimes buy a lottery ticket, K-State, KU is playing that day, you want to put a $5 bet down, you would be able to do that. While you're at the convenience store, you may also buy some gas or milk or bread, which helps the local economy. The casinos, only those counties where the casinos are located or surrounding counties get any percentages of the money that's bet. Professional sports teams, this has to do with Sporting Kansas City. We only have one professional sports team in the state of Kansas. And we're giving them greater consideration in this bill in hopes that if the Chiefs want to ever move to Kansas, they would get the same benefit. If they wanted to build a stadium on our side, they would get the same benefit as Sporting Kansas City. The casinos have, or the Senate bill is different with that. The sports facility is if the sports facility is a racetrack facility or a major multi-sport athletic complex located in Wyandotte County, they're giving some consideration there. But they have it with a minimum investment of $50 million. Redistricting on types of wagers, that's self-explanatory. You can see what Tier 1 wagers are, Tier 2 wagers are, data for determining the results in Tier 1 wagers. The reason I've got this out, and I'm going to try to shorten this, there's other conferees, but I think this will be helpful to you when you compare the two bills. One of the most important things is the percentages. I think it's our job to get as much revenue for the state of Kansas, since we own all gaming. So if you'll look on page, I think it's 6, where it says distribution of sports wagering revenue, in our bill, or this House bill, the state will receive 20% of sports wagering revenue from casinos and racetracks on wagers placed through a mobile application. That's on your iPhone. Second part, state will receive 14% of sports wagering revenue from casinos or racetrack managers or wagers placed in person, because that's a brick and mortar building, and you have a little bit more cost, overhead cost. An app is different than a brick and mortar place. The state will receive a percentage of the sports wagering revenue from sports retailers per the negotiated contract. On the convenience stores, when they get a license from the lottery to sell the Tier 1 tickets, the lottery will negotiate what their percentage would be. Under the Senate version, the state would only receive 8% of sports wagering revenue from casino managers or wagers placed through a mobile app, and the state would only receive 5.5% of sports wagering revenue from casinos on wagers placed for an in-person. So we're higher there. And the reason we wanted to do that is I have another sheet, and have you handed that out yet, Connie? It's from our research, or Jeannie, if you'd hand that out. It lists a number of states and what their percentages are. For example, the state of Arkansas has 13%. The state of Delaware has a 50%. Of course, there's a few that are, Colorado's 10%. Indiana is 9.5%. Michigan is 8.4%. New York State is 10%. North Carolina, not good at all, only 5% of gross gaming revenue. Rhode Island is 51%. Tennessee is 20%. So you can look at those comparisons from different states and what those percentages are. I think ours are reasonable, but we've got to hear from those folks and let them, and possibly modify ours. I just think the Senate's is too low. There's a number of other things that are in this comparison, and I would like for you to spend some time with it. We also have a white-collar crime. You'd be shocked at how much money is spent from the state of Kansas on offshore betting into the Caribbean. They do it by internet. So we wanted to kind of safeguard that and bring that money back to legalized betting in the state of Kansas, where the state gets its revenue. So we authorized $750,000 given to the Attorney General's office, who the KBI actually works for, and they would be able to have criminal investigators that are very proficient on computers to track those type of betting and get them back in the state and to prosecute those if they're running what we used to call in the old days a bookie. They were a bookie. You place your bets with them. So that the Senate version does have the same amount, but they cut it down to only $300,000, I think, to the Attorney General, and $450,000 to the Kansas Racing Gaming Commission. So that's a portion I would suggest you look at. And then if you go into the crime element, where we've changed certain crimes that could be charged, in sports bribery, we increase the penalty from a level 9 to a level 5, because this usually is considered, it's a lot of money. So that's the reason we raised it to a level 9, if committed with the intent to influence the outcome of a sporting contest. The Senate's version was, it was a 9 and they moved it to an 8. We also put down unlawful wagering. I think we're pretty consistent on there. We both make it 8, but we have some other factors that you need to be looking at. Online lottery ticket sales, of course, we have that included on both sides, possibly just a different version. Under the tribal gaming, we require the governor to negotiate in good faith with our Native American friends to see if they could also be entitled to sports wagering. The Senate has the same version. Jurisdiction for prosecution, we put down on the House version, the Attorney General and the Kansas Racing Gaming Commission will have the original jurisdiction to investigate and prosecute unlawful, have original jurisdiction to prosecute the sentence. The Senate bill does not include that. State set-off. We have a lot of people that don't pay child support or have other debts to the state. So we put in that all sports wagering retailers or categories or entities may contract with the Director of Accounts reports to withhold prize-winning money or prize money they win to of individuals who have a debt. If you're back on your child support and you hit it on a lottery ticket or on a bet, the state will be able to go in and recoup that money. The Senate did not include that in their bill. And of course, effective dates are July 1, 2021. That's basically the comparison of the two bills. You have two handouts. And I'll close with this. Our best legislation is when the House has a version and the Senate has a different version. We do it with our budgets, we do it with our tax bills, anything that has a great deal of money involved. So I would encourage you to go through this. We're going to work this bill at some point in time, or a version of it, and we get to conference committee, and for those freshmen, I would encourage you to go to any conference committee you can, because that's where we make a bill that we think is perfect, more perfect. And so we'll put that into a conference committee and we'll negotiate the revenue portion of it with our Senate colleagues. And hopefully at the end of the day, we will have a bill that all of us can support. But with that, Madam Chair, I will stand for questions.
Thank you, Mr. Chair. The Vice Chair has one, and then I'll open up to everybody else. Could you, or do you know off the top of your head the fiscal note between the House and the Senate version with the different?
Well, the main difference is it's projected that about $400 million will be bet in sportsbook, and that will grow each year. So based upon which percentage we actually put into law, whether it's the 20% or 14% or the 5%, that's the revenue that the state will get. Some projections have been we could get anywhere from 35 million. Let's strike that. I'm thinking of a different bill. We could get 3 million. We could get 7 or 10 million, because the margin on sportsbook is only the return to the folks that are placing the bet is like 93, 94%. So there's only a 6% margin that would go. That would be lost on any given day on a bet. I mean, the margin's about 94%, so you got 6% that the state has a possibility, or the state and the casinos or the lottery would get from the bets made, if that was helpful.
So that was, thank you. Committee, any questions? Representative Miller.
Thank you, Madam Vice Chairman. Thank you, Mr. Chairman. What size is that jacket?
It's a 46 regular, which I normally wear, but this one's a little small.
Well, since I know what you paid for it and know that it's a little small and you don't really like it, we need to talk, okay?
It would look good on you, Vic, with pink pants.
It all looks good on me, thank you. Just a I just wanted to clarify, you made a statement that we'd be surprised how much money was spent by the state of Kansas offshore. I think what you meant was by Kansans. The state doesn't.
You're exactly, by Kansans offshore making bets on the internet.
And my question is, any thoughts on the age that you can bet being 21 and not 18?
The bill has 21.
I know.
Because that's existing statute. But, I'm one of those that, as 18, I was in the United States Army, so I thought I was an adult. Probably didn't act like an adult all the time, but I was considered an adult. And you remember the days, you're close to my age, when we couldn't vote, and then we got to vote at 18.
Yeah, we're not that close in age. But anyway, my only comment about the age is that young people are betting
They are.
offshore illegally. And I would just, if they're going to do it, I would just assume that when they turn 18, they'd be doing it legally through this process.
I personally have no opposition to that, because you're correct. They're more efficient on the computers than we are.
Thank you, Mr. By the way, this isn't just blowing smoke. You give great testimony. I really appreciate the way it was organized. Thank you.
Thank you, sir.
Representative Smith.
Thank you, Madam Vice Chair. My question has to do with penalties. So I'm trying to go through this and pick out where you're in a misdemeanor, a level A, a level B, then going from a level 9 to a level 5 felony for certain actions. What if I'm just in one of these legal establishments and I'm using the information to make side bets with my buddies there? What's to keep me from doing that, and what level of crime am I committing if I'm not using their system to place those bets?
You're going to have to kind of go through that again with me.
All right, you go in.
Part of it's because I couldn't hear you, but
All right. If you go into one of these establishments that is legal to sports wager bet, and me and my buddies use the information that we're seeing up there just to place wagers between ourselves, is that a crime? And what level of crime have I committed? Because currently, that would apparently be about Class B misdemeanor right now.
and I think it would still be a Class B misdemeanor. You're doing it, you're talking about at a convenience store?
Sure, if that's one of the establishments or the casino or wherever it ends up being.
Right. The ones that we raised from the 9 to the 5, that had to do, and that came from the AG's office, but that's sports bribery.
Or influencing a
Right.
sports contest.
Right.
Right. And then there's, well,
I mean, it would also go back to sports betting. You know, the mens rea. What's the intent? So I think it would be the B misdemeanor, but you know, I would leave it up to the Attorney General, and that may be a question that I'll have Connie ask the Attorney General.
fair enough. Thank you.
Thank you, and we'll get that response back to you.
Representative Auerkamp.
Thank you, Madam Chair. Thank you, Mr. Chairman. Looking at the percentages, I guess first clarification, authorized to conduct sports wagering, first option is the Kansas Lottery. And am I correct to assume that is the Kansas Lottery can operate it, same as they operate their lottery tickets today, via similar fashion?
That's my understanding, yes.
And then when we go to percentages, the percentages address the casinos and the racetracks and other retailers. Do you recall, what would be the percentages kept by the state of the hold, that 6 to 7%? What would be the percentage of that the state would keep for the gambling done on the lottery-owned platform? So the Kansas Lottery operated and owned specifically to the lottery. They get a 6 to 7% hold of that. What percentage do you think would go to the state?
It would probably be the same as the lottery ticket sales. So I think, if I understand your question, is if you like make it in a convenience store, and if you buy, are we talking,
Would be the, let's say the lottery makes an online platform and operates it.
if the lottery would have an online platform, then they would keep the entire amount, would be my understanding, but I will get that direction from the lottery director, like they do on their lottery tickets, because there's no third person in there.
Okay. Thank you, Mr. Chairman.
You're welcome.
Thank you, Mayor.
And final question, I'm looking at the time, goes to Representative Howell.
Thank you, Madam Vice Chairman. My question is regarding the contracts. Can these online gambling platforms enter into negotiations with the Kansas Lottery on a rolling basis, or is there a certain window under this legislation that they would have to apply or enter into a contract?
You're talking about the convenience stores? Or
Yes,
anyone?
yes, or any online
Right.
platform.
I think it's kind of an open window. Presently, they have 1,700 convenience stores, although we only put, I think, 1,200 in the bill, and there are some convenience stores that will not want to do this.
Thank you, Mr. Chairman, for your testimony. Up next, we have Jason Watkins with Ruffin Companies. Welcome to committee.
Thank you, Madam Chair. I am Jason Watkins, appearing today on behalf of the Ruffin Companies and Kansans for Fair Play. Appreciate the opportunity to be here and want to say thank you to those involved in drafting this bill for including racetrack gaming facility managers, otherwise known as racetracks. As the chairman pointed out correctly, we're not in the Senate version, and we're not sure why. We didn't get a seat at that table. It really doesn't make sense not to include tracks if you're going to include casinos. So we do appreciate the inclusion in this bill. And I will be brief, Mr. Chairman, but you do have new members, and so I think there's some important information that I do share related to racetracks, because you're probably going to hear later, well, none of them are open. That's why we don't include them. None of them are open. And I think it's important that you understand why that's the case and that you understand what you can do to fix that. In 1986, voters in Kansas went to the polls and approved a constitutional amendment allowing for parimutuel racetrack, racing, wagering. In 1987, the legislature followed up and passed the Kansas Parimutuel Racing Act, allowing for the tracks to open. And they did open. We had horse racing in Kansas. We had greyhound racing in Kansas. In 2007, back when I was a member of the legislature, we passed Senate Bill 66. And Senate Bill 66 created the Kansas Expanded Lottery Act, which allowed for casinos to open. We created 4 gaming zones. And in Senate Bill 66, we also said in 3 of those 4 gaming zones where tracks are currently located, we're going to let those tracks have slot machines if the voters approve those. And in 2 of those 3 gaming zones, voters did approve slots at the track. They did not in Sedgwick County. That vote failed by just under 200 votes. And you'll run into people today that will tell you, I had no idea when I voted no what I was actually voting on. Because we had a I think it was Mr. Sterling yesterday in a committee that said it's clearly ambiguous. If you think about that for a second, that's humorous. This question that went to the voters in 2007 was hard for folks to understand. It said, shall electronic gaming machines be placed at locations in Sedgwick County? And I'm paraphrasing just a little bit. But that's the gist of the question. You had all kinds of folks that went to the polls who were fine with slot machines at the Wichita Greyhound Park. Why would you not be? People are betting on dog races. Well, folks thought that meant, oh, we're gonna be like Nevada. We're gonna have slot machines at the Quick Trips, and I don't want them next to my kids' school and my grandkids' school. So the vote failed. And shortly after that, the Wichita Greyhound Park closed. Now, I've watched this gaming issue over the years as lobbyist after lobbyist after lobbyist, and legislator after legislator came forward and tried to fix the problems. There's two primary problems. One, Sedgwick County needs to have a vote again. In a poll 2 summers ago in August, an astounding 92% of the people polled in Sedgwick County said, yeah, we ought to be allowed to vote on that again. 72% said they'd vote for it. Those are big numbers. The other issue is Senate Bill 66 came out and said the casinos will pay 22% of the profit to the state. Not for the racetracks. They pay 40%. That's why in 2 of those gaming zones where they're allowed to have slot machines, they don't. They're not open. It's real simple. They can't make money. The casinos get to make money, not the racetracks. So the racetracks are closed. It's a lot of economic development opportunities that have been squandered. It's a lot of jobs, and it's a heck of a lot of tax revenue for the state of Kansas. And it's a simple fix. Let the tracks pay 20%, just like the casinos. And I'll wrap up here, Mr. Chairman. The reason you haven't done that is because every time you consider it, every time somebody like me comes up here and says, change that unfair tax rate, the casinos tell you, you do that, we'll sue you. You can't make any changes to Keela. You can't expand gaming. Well, I'll remind you, casinos were in Senate Bill 66. So when they tell you that allowing slots at tracks is an expansion of gaming, they're simply wrong. That was already contemplated in Senate Bill 66. Frankly, it's insulting. They'll tell you it's going to cost you $1 billion. You do any of this, you, state of Kansas, are liable for $1 billion. I agree with something that was said a little bit ago by the representative from Topeka. The chairman did a great job testifying. And he said something that I agree with 100%, and it should be said over and over and over. The casinos do not own you. You own them. You can fix this problem. You can open these tracks back up. You'll see hundreds of millions of dollars in capital investment. You'll see hundreds of well-paying jobs. And your state general fund will reap a lot of benefits. I went on longer than I planned to, Mr. Chairman, so I appreciate the time. I'll stand for questions.
Questions for the conferee? Representative Miller.
Thank you, Mr. Chairman. If we were to put the tracks on the same footing as the casinos, and if indeed they sued us, the state, would your clients be willing to agree to indemnify the state for any losses from that lawsuit? Because as I remember the discussion a couple of years ago, our own lawyers, the state's own lawyers, were saying they felt very vulnerable to that lawsuit. So that's my question.
Yeah, I think there's been a lot of different versions of how that could be worked out. I think that my client is willing to indemnify or participate in indemnification at some level. And I'd be happy to discuss that more. We actually have some ideas on how we might be able to structure that. We actually have some ideas on how we think we can find out what that liability is before anybody's actually liable. We don't think that liability exists. But I appreciate the question, Representative.
I appreciate your position, but I don't want to be the one that's gambling that you're right or wrong. Thank you, Mr. Chairman.
Thank you. Representative Epley.
Thank you, Mr. Chairman. And again, I want to thank you for your prior testimony. And Jason, I really want to thank you for being here and trying to educate all of us, get us up to speed on this. You went there, and so I don't know if you have any data to really help the group come to terms with, but of the economic impact, if we did go forward with your proposal on those 5 areas, those 5 racetracks, both locally and also to the state. Do you have any data at all you can share with us on the positive financial impacts? Thank you, Mr. Chairman.
Yeah, there was an economic impact study that was done a few years ago, and I didn't bring that with me. I will get that to the committee, but as I was stating, you know, it's the income and sales tax generated. Right now, those tracks are old. Phil Ruffin just bought the track 2 years ago in the Wichita area. It was owned by the Sedgwick County government. Mr. Ruffin has purchased that land, which shows his longstanding commitment to trying to get this track back open. But if we can create the situation where he can, you're looking at significant investment just in new buildings and construction. The capital investment would be astounding. And then there's the tax revenue that you're not getting off of racing and that you're not getting off of those slot machines. And a major issue, and I don't know if this committee is aware of it or not, that track in Wichita, Mr. Chairman, sits at about I-35 and 77th Street. Directly across the street, the Wyandotte Nation has opened up a casino. You're getting 0 of that. We'd like to give you 22% of our slot revenue.
Thank you. Representative Clayton. Last question.
Thank you, Mr. Chair. Thank you for being here today. And this might be something that you can provide me offline. I'm a very strong supporter of your issue. Just want to know a little bit more about the Wyandotte County and Kansas City area and how that's looking. So you can either do that here or you can just send me something, but I would like an update. Thank you.
Yeah, and Mr. Chairman, first of all, I thank the representative for her longstanding support. The property where the horse track was in Wyandotte has been sold, but you still have in law that gaming zone, the Northeast Kansas gaming zone, can have pari-mutuel with slot machines. So just because the land has been sold doesn't mean that Mr. Ruffin or somebody else couldn't come in at some point and open a facility.
Thank you. You'll send us an economic impact report.
Yep, absolutely, Mr. Chairman.
And Connie can get it out to the committee. Thank you, sir.
Yep, thank you.
Last proponent is Tom Palance, Fuel True. Good morning, sir, and welcome to Federal and State Affairs.
Thank you, Mr. Chair. Mr. Chairman, members of the committee. My name is Tom Pallas, and I represent Fuel True Independent Energy and Convenience Retailers. And I have to reiterate the comments made earlier. The chairman did a great job of explaining why we are here today. I represent a little over 1,100 retail facilities in the state. There are over 1,600 lottery retailers in the state, but of which, of the convenience store side, I'm about 1,100. And we support this bill. We are the conduit for the Kansas Lottery for lottery tickets, and actually we're the backbone of the Kansas Lottery selling Powerball and scratch-off tickets. So we feel it's a natural fit for any game that the lottery has or can offer to Kansans that we, the lottery retailers, can participate. Obviously, we would participate as a Tier 1, as the chairman indicated in his testimony. We're prepared to do that. And I agree, I don't know how many of our members would participate. I've had some of our larger chains have indicated they want to participate in this endeavor. So I will tell you that lottery tickets are not a huge revenue generator for us, but it brings traffic into our stores. And when it brings that traffic in, we also sell supplemental products, as you heard earlier. We think that with the gaming piece or the ability to make a bet on your favorite sports team would also bring more traffic into our stores. And we have realized that these bets are going other places. And as we all heard earlier, that they're better off being right here in the state. Again, with the sports gaming for our members, we don't anticipate that being a huge moneymaker. We make 5% per lottery ticket that we sell. And we don't know what the compensation will be from the lottery. We basically, as I said, we're their conduit. They give us the opportunity to sell these games, brings people into the store, generates money for the state of Kansas through sales tax revenue. So I don't have a huge, I was going to use dog and pony, but that'd be a bad connotation in this situation. But it is something that we appreciate being included in, and we appreciate the fact that we're in the bill.
Thank you. When those sales take place, that sales tax goes to the local communities.
Correct.
So it helps the local communities.
That's correct, city and county.
Tax base.
You're correct.
All right, thank you. Questions for the conferee? I see no questions. You did a great job. Thank you for coming here today. Committee, I have no other proponents appearing in person unless they would stand and be recognized. Seeing none, I would direct you to the written proponents from Jake Reed, Sporting Kansas City. Do we have? You have a question?
Yes, sir, Mr. Chair.
Go ahead. I'm sorry, I didn't get your.
That's all right. I'm not tall enough behind this post.
Was that a question for the last conferee?
Well, sir, Mr. Chair, I believe it may be for the reviser, if that's okay.
Okay, go ahead. Matt, you're on, right?
Yes, Mr. Chairman.
Go ahead, Representative.
Matt and Mr. Reviser, could you explain to me on page 2 of the bill, starting on line 4, where it mentions the number of sports wagering retailers shall not exceed?
I'm sorry, I'm having trouble hearing you. I can't hear what you're asking.
On page 2, line 4, it begins with the number of sports wagering retailers shall not exceed 1,200. Sports wagering retailers shall offer only tier 1 sports wagers. What does this look like? Would this be like an application process where they would apply to do these things? And who would be up for bid on this? What would it look like?
I can answer that.
Okay.
There's 1,700 retailers that presently sell lottery tickets, around 1,700, 1,690, something like that. When we drafted the bill, we knew that not every retailer of the lottery would tickets want to participate in this. So we came up, and it was subjective on our part. We came up with 1,200 because the lottery indicated probably not more than that. Then those retailers would apply and meet the criteria, of course, to get a license, much like they do with a lottery ticket. Make sure the background checks were done and those type of things. And then there would be a licensing fee that they would need to pay to the state of Kansas, to the lottery, to get a license to sell the tier 1 tickets, if that was helpful.
Yes, sir. Thank you.
But the number was just subjective. We didn't actually pull it out of the air, but it was pretty close because the lottery had indicated that they had 1,700 retailers. Not all of them had wanted to do that. So that's where the 1,200 came from.
Thank you, Mr. Chair. If I may, does it matter on the size of the retailer, on how big they are, or can it just be ma and pa's, or is it chains also?
I think the same criteria is to sell lottery tickets.
Okay. Thank you, sir.
Yeah. Further questions? Seeing, oh, sorry. Representative Penn? I see clickers back here.
Thank you, Mr. Chairman. Just a quick question. You may be able to speak to it on behalf of the constituency that I represent. When you talk about the amount of money that's placed into the pot for those that might have gambling addiction problems and things of that nature, could you please speak to that? How do we come up with those figures? How sufficient is it?
I can, and it's in your handout. I think it goes up to $80,000. Page 7. Thank you. Did you find it? Oh, okay. Yeah, we, in this version, the annual transfer to the problem of gaming and addiction grant fund increases from 80 to $100,000. Goes up $20,000. I find this, and I need to thank Matt for putting this together for us. I just thought it was very helpful when I received that yesterday afternoon, and I wanted to get it out to you. And I wanted it in a paper form because we can look at it on the internet, but if you're like me, you like to carry it around and highlight certain areas. But I have directed the written proponents, Jake Reed, Sporting Kansas City, as a proponent, Allison Metzi, Kansas Association of Broadcasters, have their testimonies in your file. Please read over that. Committee, we've got about 30 minutes here. And I'm looking at bringing up a bill on the infectious diseases 2224. This is the one that we had a hearing on where we talked about infectious diseases. Upon convictions, the court could do certain things. There was one opponent to it. There was an agreement that they would draft an amendment. It's 2224. As to House Bill 2224, what is the pleasure of the committee?
Thank you, Mr. Chair. I move that we pass out 2224 favorably for passage.
Thank you. Do I have a second? I have a second from the Vice Chair. Discussion, Representative Smith. Matt, we have an amendment. Give me that was supplied to us. Give me 2 copies. The amendment will be handed out. Basically, Matt, would you explain the amendment?
Yes, Mr. Chairman. I'll pull it up on my screen. The amendment, if you look in section 2 of the bill, a lot of it just kind of reorganizes. I think as some of the questions that were indicated in the hearing were kind of confused about how it applied to various persons. So it kind of reorganizes it and makes clear that that the court shall order a person arrested and charged to submit to infectious disease tests if, 1, the victim of the crime or the county or district attorney requests the court to order those tests of the alleged offender, or 2, the law enforcement officer or such person stated they had an infectious disease or were infected with an infectious disease, and they said that to a law enforcement officer. And then that testing would occur within 48 hours. And so then those results would be provided.
Matt, I need to stop you there. Committee, the amendment that was handed out is not the amendment that's on the screen. This was the old amendment that was copied. There is a new amendment. So I'm going to ask Matt to go over it again. The one that was handed out is not the amendment.
I think... okay, thank you, Mr. Chairman. I think there was an original one that was that didn't address all the concerns, and so I think this is the one that we had talked about that addresses those additional concerns. So, as I said, this would clarify who exactly, under what circumstances the court shall order a test of an individual, and essentially that would be if the victim of the crime or the county or district attorney requested the court to order tests of a alleged offender, and then 2, if that person who had been arrested had stated to law enforcement that they had an infectious disease or were infected, then the court would order that person to submit to infectious disease tests. Additionally, if you go to the last page of the bill on page 3 here on the amendment, there was some concerns about the costs of any counseling and testing. Under the original bill, the court would order those costs to be paid by an arrested or convicted person to pay restitution. The amendment would strike that arrested, and so costs would the court could only order costs for an individual convicted to pay restitution to the Department of Health and Environment. And I'd be happy to answer questions if any of that wasn't clear.
Committee, I don't feel comfortable going on this amendment today because you don't have a copy. Now, if you were in other committees, they would go forward because there's no requirement to get you a hard copy. I like hard copies. And in this committee, we will do that. So I'm going to leave this bill open until tomorrow, give you an opportunity to look at the amendment. It is the amendment that was agreed upon by all the parties, and it's probably not controversial. Law enforcement agreed to it. However, I'm just more comfortable if you, Representative Carpenter, you want to interrupt me for some reason?
I was waiting until you finished, but I wanted to ask a question of the revisor about the current language, if I could.
Well, I'm going to wait until the bill, till the amendment gets out to everybody so they can have it, and I'll give you that opportunity tomorrow. With that, we're going to leave this open. Connie will get it out to you. I will have hard copies tomorrow. We will take this up at the conclusion of the opponents tomorrow, but you'll have the copy before then. So check your emails. If you want a hard copy, we'll have it for you tomorrow. Anything else for the good of the committee? We stand adjourned.